Okay, we're here on the plea to the jurisdiction in the case against the governor. Mr. Friedman, if you could make your announcement, include the name of the case, as well as the cause number and the folks who are here with you. And then Mr. Dower, if you could go ahead and introduce yourself as well for the record. And we are on the record, Tony.
Sure. Your Honor, my name is Larry Friedman. We're here today to present our arguments in cause number D as in David, C as in cat, -20-09166. It is styled STIRR, STIRR Dallas, LLC et al. Versus Gregory Wayne Abbott in his official capacity as governor of Texas in the District Court of Dallas County, Texas, 68th Judicial District. I'm here today with my partners, Jason Friedman, Caitlin Beeman, and our legal assistants, Marion Al Ghaziani and Scott Scher.
All right, Mr. Dower.
Good morning, Your Honor. My name is Benjamin Dower, and I'm here on behalf of the defendant, Gregory Wayne Abbott, in his official capacity as governor of Texas.
It seems to be a bit of a trend in this case that briefing is provided to at the last minute to the court. Last week, Mr. Dower, you provided some last minute briefing that I considered, and Mr. Friedman, you just provided me some last minute briefing. Mr. Dower, have you had an opportunity to look at the most recent brief?
Yes, Your Honor.
Plaintiffs. Are you prepared to respond today, or what is your?
Yes, Your Honor. I'm ready to proceed if you are.
I'm not sure I am, because I just got this brief and I've read it once rather quickly. So we'll see if I can make a ruling today, but I do want to hear both sides' arguments. So Mr. Friedman, you may proceed.
All right, I think it's the governor's motion or plea to the jurisdiction.
I'm sorry, Mr. Dower, you're right. Mr. Dower, you may proceed.
Thank you, Your Honor. Today, we're here on the defendant's plea to the jurisdiction. We ask the court to grant the plea and dismiss this case for lack of subject matter jurisdiction for two reasons. First, Your Honor, the plaintiffs lack standing to sue Governor Abbott because Governor Abbott does not enforce GA 28, which is the executive order they seek to challenge. And second, Your Honor, the plaintiff's claims are barred in their entirety by sovereign immunity. To get right into it, Your Honor, standing requires not only an injury in fact.
Mr. Dower, who is the right party in your opinion then? If it's not the governor, who is the right party?
I think there's two potential right parties, Your Honor. One would be the Texas, or I guess the commissioner of the Texas Alcoholic Beverage Commission, which would be the entity that does the regulatory enforcement, or it could be potentially if GA 28 was enforced by law enforcement, then that could be the potential that could be a potential defendant. And part of it is that the plaintiffs have gone to the courthouse before any action was taken to apply GA 28 to them, and so it's a little bit speculative right now because no action has actually been taken to apply GA 28 to them. They just want to challenge it. But what we're really focused on here is the fairly abundant case law that says that when you challenge a law, you have to sue the entity that is actually enforcing that law. It's kind of like the legislature. Legislatures pass laws and people try to avoid violating them in their daily lives, but you don't sue the legislature for passing the law because it doesn't really, the injury comes from when the law is enforced on you by some authority. And so in order to establish standing, you have to show an actual enforcement connection between the act that you're challenging and the act that you seek to be enjoined. And so if this court were to enjoin Governor Abbott, for example, the Texas Alcoholic Beverage Commission could still go out and enforce GA 28. They would not be bound by the injunction because they're not a party and they're not in the office of the governor. And so that just sort of demonstrates the gap between the defendant they've sued and the standing issue. You have to be able to show that you're enjoining a defendant who has the power to take the action that you seek to enjoin. You can't enjoin an act that they have no power to do in the first place. And so if someone violates GA 28, for example, by operating a bar that they're not allowed to operate, it will not be someone from the office of the governor that goes in to enforce GA 28. It will be one of these other bodies. And so even if this court enjoined the governor's office or the governor in his official capacity, that wouldn't prevent these other unrelated third parties from taking those actions.
What if the court issued a declaratory judgment?
The same thing applies, Your Honor. A declaratory judgment has the same effect as an injunction. It has to be against the specific party for whom the injury is related. Because otherwise, think about it this way, you could sue anyone. I could sue my neighbor and get a declaration and then try to enforce that declaration as to some third party. The power of the declaration is its prescriptive force against the defendant to whom the declaration is issued or directed. And so for the same reason that the court would need to have the appropriate defendant to enjoin, the court would also need to have that same connection to the declaration. Otherwise, it's an advisory opinion that I'm sure the court knows that it doesn't have jurisdiction to issue. It's effectively just addressing it in the abstract. And so the Texas Supreme Court recently held that when the executive order is not enforced by the governor, then you lack standing to sue the governor for basically the reasons that I've outlined. And that's the N. Ray Abbott opinion that came out in April of this year. And in the plaintiff's response, they're very focused on the fact that the governor issued GA 28. And of course, certainly that's something we wouldn't deny. The governor issued GA 28. But there's a fundamental difference between issuing an executive order and it looks like Your Honor's bringing up a case for me. Should I stop speaking so that Your Honor can ask me a question?
No, I'll ask you a question when I'm ready.
Okay, I apologize for jumping the gun, Your Honor. So you have to be able to show that the defendant that you're seeking to enjoin actually enforces the order.
So kind of explain to me this decision I have on the screen, the N. Ray Salon a la mode.
Well, Your Honor, my understanding is that they denied a petition for writ of mandamus, and there's a, I'm starting to get some reverb. And that there was a concurrence by one of the justices joined by some of the others talking about how the Constitution is not suspended, which is certainly not a position that we're taking here. I'm so apologize, Your Honor. Do you have a more specific question?
I mean, if you read the language of this, and you know, these are unusual times, and I have to follow the prescriptions of the Dallas Court of Appeals and the Texas Supreme Court. And it says here, with I guess in the concurrence, when constitutional rights are at stake, courts cannot automatically defer to the judgments of other branches of government. When properly called upon, the judicial branch must not shrink from its duty to require the government's antivirus orders to comply with the Constitution and the law, no matter the circumstances.
I guess, Your Honor, I would focus in on the phrase properly called upon, because Your Honor has not been properly called upon at this point, because they haven't sued a party sufficient to confer standing upon this court. I would also emphasize that in this case, we were talking about someone who had been jailed rather than in this case where a business might shut down, there might be $1,000 monetary fine, but GA 28 is not enforceable through any sort of imprisonment or jail time.
Why does that matter?
It affects the nature of the interest, Your Honor, for the equal protection argument, for example. That implicates the fact that we're under rational basis review. The bottom line, Your Honor, is that I'm not asking the court to suspend the Constitution, far be it. I'm asking for the court to properly apply the Constitution, including the separation of powers that prevents the court from issuing advisory opinions.
But at this point, you are taking the position that I'm not getting into the issue of whether or not I'm going to grant the temporary injunction or not. I have severe questions about the injunction. and whether or not it's appropriate. But at this threshold is, do I, as a district court in the state of Texas, have the right or the jurisdiction to hear this case? And it says here, the next paragraph, it says, this original petition, which challenges several local officials' coronavirus responses measures, should first be presented to the appropriate district courts.
Yes, Your Honor.
The Supreme Court is generally a court of last resort. Why is this any different? Why wouldn't this court have jurisdiction here? You've taken the position in this case that only the Texas Supreme Court would have jurisdiction, but they seem to be saying exactly the opposite.
You know what, Your Honor, that's not what we're saying. And I have to sort of correct or explain one of our arguments. I think Your Honor is referring to this sort of middle argument in the plea, talking about chapter 22.0, I think 02C, that talks about the Supreme Court having exclusive authority for the writ of mandamus or injunction. And let me clarify what we were arguing there. Is that part of the confusion that we had in reviewing the plaintiff's brief is that on paragraph 90 of their petition, they said that they wanted a temporary injunction against the defendants, enjoining them, his agents, representatives, employees, or anyone acting on his behalf, including the TABC. And so the problem is, of course, that as I was just talking about in the context of standing, the TABC is not a defendant in this case, and neither are any other state or county or city entities that are not defendants. And so to the extent that what they were doing was asking this court to compel the governor to take some action against third parties that are not before the court, that would be implicated by chapter 22.002C. But you're right, Your Honor, that I think that that really what we're arguing here is standing and sovereign immunity, not that this district court doesn't have original jurisdiction over this case. And if that wasn't clear in the brief, I apologize, Your Honor. And I will say this: I know that Your Honor said about that you got the plea to the jurisdiction right before the last hearing. I would just remind the court that we found out about this case on Friday and the hearing was on Tuesday. And so we only had about a business day and a half to get our plea to the jurisdiction on file. And I know that sounds like an excuse, and I don't mean to make excuses, Your Honor, but if there are deficiencies in the belief in the briefing, the responsibility is with me.
No one is criticizing you.
I appreciate that, Your Honor. So let me talk about sovereign immunity a bit, because that's the second and I think equally important argument. And it's in some ways more important because it would apply to whoever they sue, even if they sued a proper defendant. Sovereign immunity would still bar the claims. So sovereign immunity is, of course, the idea that you can't sue the sovereign state of Texas without its consent. Sovereign immunity actually predates the United States Constitution. The states had sovereign immunity even when they were in the Articles of Confederation. So this is a very, very old doctrine, like I said, that actually predates the United States Constitution. Now, there is a means by which you could potentially get some relief, even in the absence of the state giving permission to sue it. And that's the ultra vires exception that the plaintiffs are trying to invoke here. And the idea is that if you're trying not to exert control over the state, but bring it back into its constitutional alignment, then it's not barred if you're seeking some sort of prospective relief. It won't let you get damages, but you can bring the state back into alignment. But that's only true if you've pleaded a proper, viable claim. If the facts you've alleged, or including potentially evidence, are not sufficient to demonstrate that what you've alleged is actually an unlawful act by the state official you are suing, then sovereign immunity continues to bar the claim. And that's very well established. I think the plaintiff's response argues that the merits and the sovereign immunity are different, and the court can't consider the merits in the context of sovereign immunity. And respectfully, Your Honor, that's just not the case. The Texas Supreme Court has held many times that when the plea to the jurisdiction challenges the pleadings, we determine whether the pleader has alleged facts that affirmatively demonstrate the court's jurisdiction to hear the cause. That was a 2012 Texas Supreme Court case called Texas Department of Parks and Wildlife versus Miranda. And so when the plaintiff, as here, has not alleged facts that actually demonstrate that the defendant they've sued has acted unlawfully, then they've not actually overcome sovereign immunity. And that may intermingle the merits of the case with the jurisdictional issue. And again, that's totally fine. The Texas Supreme Court said in 2009, for example, that when the facts underlying the merits and subject matter jurisdiction are intertwined, the state may assert sovereign immunity from the plea to the jurisdiction, even when the trial court must consider evidence necessary to resolve the jurisdictional issues raised. And so from a procedural standpoint, Your Honor, there's nothing wrong with the court implicating or looking at the whether or not they've actually alleged something unlawful, a violation of the Texas Constitution. And in fact, the court needs to analyze that to determine whether or not it has subject matter jurisdiction to hear the case. So with that sort of backdrop in mind, let me explain to the court why Governor Abbott's issuance of GA 28 was indeed lawful, and therefore he still retains sovereign immunity. Let's start with the statutory authority. So GA 28 is authorized by the Texas Disaster Act of 1975. And specifically, the Disaster Act says, it's in Texas Government Code Chapter 418.018C, that Governor Abbott has authority to control the ingress and egress to and from a disaster area, and the movement of persons and the occupancy of premises in the area of the disaster. And so the occupancy of premises and the limitation thereto is what authorizes, or at least one of the provisions that authorizes GA 28. GA 28 says, people shall not visit bars or similar establishments that hold a permit from the TABC and are not restaurants as defined and above in paragraph 6, provided, however, that use by such bars.
I guess it kind of seems to me that your argument kind of undermines the whole concept of judicial review. I mean, if a sovereign can take the position that, look, I can issue any order that I want without regards to whether or not it complies with the Constitution, doesn't that undermine the entire concept of judicial review?
It certainly would if that's what you're saying, Your Honor, but that's not what I'm saying. And I apologize if I'm not being clear. The point is that they have to allege something that actually violates the Texas Constitution in order to get past sovereign immunity.
But aren't they arguing that this order, because it is so restrictive, is violating the Texas Constitution's Equal Protection Clause?
That's the contention, Your Honor, but it's not borne out by what they've alleged. In other words, if we accept all the facts as true, they still have not alleged an actual violation of the Texas Constitution, and therefore Governor Abbott's sovereign immunity is retained because of what the Equal Protection Clause actually imposes as a constitutional mandate for restrictions that don't implicate any protected category, which is the case here. And so because GA 28's distinction between bars and restaurants is rational, it doesn't violate the Equal Protection Clause. And because it doesn't violate the Equal Protection Clause, sovereign immunity is retained. And so I'm not saying that the governor is immune from violations of the Texas Constitution. What I'm saying is the plaintiff has to actually allege a violation of the Texas Constitution in order to get past sovereign immunity, and they simply haven't done so here. So let me explain to the court why GA 28's distinction doesn't violate the Equal Protection Clause. First of all, Your Honor, the level of scrutiny that the Texas Constitution imposes under the Equal Protection Clause varies widely depending on whether or not a suspect class or fundamental right is implicated. Certainly, if there's a government distinction based on race or gender or implicating a fundamental right, there's a different level of scrutiny, a higher level of scrutiny that's imposed rather than a purely economic interest. And so the Texas Supreme Court has consistently said that courts apply the rational basis test to uphold the constitutionality of regulations affecting economic rights. And under rational basis review, Your Honor, the party challenging the rationality of the classification has the burden of negating every conceivable basis that might support it. And that's, I'm quoting here from a 2013 Dallas Court of Appeals case called Gardner versus Children's Medical Center of Dallas. And so the plaintiff has to show that there is no conceivable basis to support this distinction. Rational basis can be unsupported by evidence or empirical data. That's from a Texas Supreme Court case from 2015 called Klum versus Houston Municipal Employees Pension System. The defendant has no obligation to produce evidence to sustain the rationality. That's from
Mr. Dower, I really feel like you're arguing the merits here, not the issue of jurisdiction.
Well, Your Honor, the merits implicates jurisdiction, because if they don't have a meritorious claim, sovereign immunity is retained, and therefore the merits and sovereign immunity are intermingled.
Let me ask this. I'm jumping ahead a little bit, but you had told me that you were going to provide me some case law or briefing on the issue of whether or not I can order discovery in this case. I didn't see any briefing on that. Has that been filed and I just haven't seen it, or did you not get a chance to do that?
No, Your Honor, I apologize. I actually have the briefing and a draft ready to go. I wasn't entirely sure whether it was Your Honor was expecting that, given that I cited some of it in the pleading. But if Your Honor would like, I can file that within an hour, I think, of this hearing, if Your Honor wants to see that authority. Or I could cite some cases right now. It's up to you.
I mean, I was hoping to have the briefing. None of this has been easy for anyone. I know. I know that you had to do things last minute. I know Mr. Friedman did as well. I think I made it pretty clear last time that I wanted that briefing. And you were all supposed to get me the name of a designee of the governor that could testify if that was necessary. Did you do that?
Well, Your Honor, can we talk about that in a second, or would you like to talk about it now?
I kind of like to talk about it now.
Okay. All right. Well, let's talk about it now. So, skipping ahead, then, Your Honor, so it depends, Your Honor, on what the purpose of the witness is, because given that rational basis review doesn't implicate any evidentiary review, and it doesn't implicate what the decision maker made, it wasn't entirely clear what this witness is supposed to testify on to me. And normally, of course, when you designate a witness, you get, if it's like a corporate rep depot, like Your Honor compared to, you have the topics in advance. So you work backwards from what the person is supposed to testify to. And in addition to that, there's also a very core privilege that's implicated by asking questions about what was considered or what were you thinking, because there's a deliberative process privilege that shields all of that information from disclosure. And so in addition to sort of the jurisdictional issue about courts are not, here I'm quoting from a Texas Supreme Court case, that the entitlement to be free from suit is effectively lost if the trial court erroneously assumes jurisdiction and subjects the governmental unit to pretrial discovery and the cost incident to litigation, which is a Texas Supreme Court case from 2004. In addition to those concerns, Your Honor, there's also sort of an issue of, well, what is this witness supposed to testify to? And that sort of informs the designation. And if they're supposed to be testifying to what was supplied to the governor or what was he thinking, that all that information is going to be shielded by the deliberative process privilege. So,
Mr. Friedman, I think there was two individuals, and what was it called? The business task force? Someone with the hotel industry, and there was somebody with another
restaurant industry and the hotel industry. Here's the crux of it, Your Honor. When we had the hearing last time, and now I'm listening to Mr. Dower again, we pled a violation of the Equal Protection Clause of the Texas Constitution. That's a viable claim, and that gets around, or that does away with their defense of sovereign immunity. The other thing is, we've asked Mr. Dower last time and this time, and I've asked him off the record, to articulate any distinction between the standalone bars and the other bars in hotels, restaurants, and everywhere else. And he's not been able to do that. And that's the rationale that he can't measure up to, that the governor can't measure up to. And that's the scrutiny that this court must take. He has not been able to articulate any distinction between the standalone bars and the other bars, yet one category of bars has been shut down and the others have been allowed to continue to operate in business.
Your Honor, may I respond, please?
That's
You
the
may.
crux of the claim.
Was that a yes, Your Honor? I apologize.
Yes.
Okay, the hotel bars are not allowed to operate unless they serve more food than alcohol as per the executive order. I don't know where this distinction is coming from, that hotel bars are open and other places are closed. It depends on the exact same criteria for standalone bars. Is the place selling more, getting more of its revenue from food than alcohol? This distinction isn't in the executive order, and I'm really not sure where it comes from. And that kind of goes back to the problem of who they sued. They haven't sued the entity that enforces the order, but I don't know where this distinction is coming from because, you know, I mean, I can't reveal any privileged communications, but it's not in the executive order, and I don't think it's how the executive order is being enforced. It's all based on revenue sources, just like the executive order says. So this distinction between standalone versus hotel is not there in the executive order. And I don't think that's an actual distinction that it makes.
Well, that's cute, but the 51% alcohol has no rational basis, and the hotel bars are permitted to include the revenue from guests, from hotel revenue, compared to the alcohol revenue.
Your Honor, I
So-
don't think that's
so-
accurate, and I'm not sure where it comes from.
Well, I don't mind finishing. So it's not a rational basis to close the standalone bars.
Your Honor, all I can say is that I don't believe that's accurate from conversations I can't disclose because they're privileged communications. But I don't believe that's even true as like a factual matter. And in any event, it's very focused on how it's being enforced, which is by a party that's not even in this case, the TABC. And so the part of it is we're talking in these abstractions, but we don't have the defendant who's going to be responsible for actually applying the executive order in the case, who's going to make these decisions about what it means and how it applies. But I mean, if you wanted to talk about things like, I don't know, like bowling alleys, I mean, I think it's pretty easy to say that a bowling alley is easier to engage in social distancing. People generally don't go to a bowling alley in order to become inebriated, you know, for that aspect. So I think there are certainly rational bases why a bowling alley.
I've been to a few bowling alleys, and there are quite a few people who are inebriated there. So
not as much as a bar, Your Honor.
maybe not as much as a bar, but
not as much as a bar. But I will agree that is definitely a phenomenon that happens. I would say people, you've never heard of the phrase going bowling alley hopping, for example. I think we've all heard bar hopping, Your Honor. People go from bar to bar on 6th Street. I'm not familiar with people doing that for bowling alleys.
Okay, but I want to focus on the jurisdictional arguments because that's an argument that they can't meet. I want to focus on the standard for jurisdiction because we can get over the jurisdictional argument. They haven't given you the name of any alternative to Governor Abbott who can justify the policy. That's what we were focused on last week, was the name of somebody who can focus on the policy. Robert Rowling was one person we asked for because he was on the task force and he is in the restaurant business. And Tony Ferhada, I think, was the other one who's in the hotel business. So we had two alternatives. Those people haven't been offered. Governor Abbott hasn't been offered. We need to focus on where we are today. And we can address every single argument that Mr. Dower has made and would like an opportunity to do so.
okay.
Well, Your Honor, I guess what I would say is they have the threshold burden to show or to allege facts that would actually overcome sovereign immunity by showing that this lacks a rational basis. And to put that I mean, that's their burden, both in the terms of establishing the court's subject matter jurisdiction and under rational basis review. And there's legion of case law that basically says that you have to get past sovereign immunity before you get to subject these high-level people to an interrogation. And in addition to that, what they're asking about to justify the policy isn't the legal standard. You don't have to ask the people on the task force. The only question is, can we plausibly come up with a rationale sitting here, like we just did for bowling?
No,
for
we're
example?
missing the mark. The court said, either give me the governor or give me two names. The court didn't make a ruling. The court said, give me the governor or give me two names. And again, the governor is defying the court because the governor said, I'm not giving myself up for discovery, and I refuse to give the 68th Judicial District Court any names. It's the same thing we did last time. The court said, what's the rationale for 51% as opposed to 50% or 49% or 61% or 32%? And Mr. Dower is here today with no rational basis for a 51% cutoff. And I've got 50,000 people who are out of work, soon to be out of their homes, and not be able to feed their families because somebody made up an irrational cutoff at 51%, and nobody can justify it.
Your Honor, I don't want to keep going back and forth, but I would like to respond if we can.
No, Mr. Dower, you had a long time to speak. Let Mr. Friedman have a chance.
Okay, Your Honor, we're not here for an academic exercise. We're not here to reinterpret the Texas Constitution. We're not here to be the seminal case on enforcement of executive orders. My clients are here today for equal protection under the law and due process. I've got 50,000 people behind my plaintiffs here that can work, want to work, and need to work. And this order, this executive order, flies in the face of the Supreme Court mandate in Ray Salon a la Mode, where the Supreme Court has said, and I quote, demonstrate both to its citizens and to the courts that its chosen measures are absolutely necessary to combat a threat of overwhelming severity. The government should also be expected to demonstrate that less restrictive means cannot adequately address the threat. And the Attorney General, on behalf of the governor, has failed to do that. The Supreme Court's instructions, as far as the governor is concerned, become meaningless because the Supreme Court has mandated that this court and every other court in the state of Texas should hold the governor to his constitutional responsibilities. I'm going to ask Ms. Beeman from my office to address one of the three arguments that the Attorney General has made on behalf of the governor. If you would, Ms. Beeman.
I'd be happy to. As a almost housekeeping matter, I want to ask if the Attorney General has abandoned his argument that Section 22.003 of the Government Code somehow plausibly could prevent this suit from going forward.
I would say that it only applies to the extent the plaintiffs seek a mandamus action. And if the plaintiffs say that they don't seek a mandamus action, then that argument doesn't apply.
I think we're in agreement on that. So I will quickly address the Attorney General's arguments as they pertain to sovereign immunity. The governor's argument is premised on the fact, first of all, that there is a rational basis test at issue here. And with this virus, in these circumstances, the Texas Supreme Court says in Salon a la Mode that whether it's strict scrutiny or some other rigorous form of review, courts must identify and apply a legal standard, which should judge the constitutional validity of the government's antivirus actions. Governor Abbott's assumption that this is all just based on a rational basis review is unfounded and directly contradicted by the Texas Supreme Court as it pertains to this exact virus. And they have not brought forth any other cases as it pertains to this exact virus in this state that say otherwise. Beyond that, their only route to somehow take away Governor Abbott's or somehow bring Governor Abbott back under his shield of sovereign immunity is to allege that we have failed to plead a viable claim. I would argue that 38 pages of response briefing to our TRO would indicate that we have somehow at least pled somewhat of a viable claim, that any attempt to go past the pleadings at this stage is inappropriate. And I would remind the court for this record that the plaintiff is to be given every, deference. We're supposed to interpret liberally in favor of the plaintiffs and look to the plaintiff's intent.
Do you have anything else, Ms. Beeman?
No, I will just briefly conclude on that by, deferring to my arguments in my briefing, but also saying that there is absolutely no way that the government can shield itself from sovereign immunity for unconstitutional actions. If sovereign immunity were the standard which Mr. Dower proffers at this stage, the Constitution would have no bite and judicial review would be meaningless. And on that, I close.
I just want to mention the argument that the Attorney General makes that the plaintiffs have no standing to seek an injunction because the governor has no enforcement authority and has not exercised any enforcement authority, if I may, Your Honor.
Okay.
I think Mr. Dower has already conceded this because he refers to the Texas Disaster Management Act, Section 418.173 in his argument. But he says that the governor allegedly has no enforcement authority and hasn't exercised any enforcement authority. Yet the plain reading of the executive order, GA 28, refers specifically to the Texas Disaster Management Act and Section 418.173. That act specifically provides for the governor to enforce his disaster plans, and 418.173 specifically states a state, local, or interjurisdictional emergency management plan may provide that failure to comply with the plan or with a rule, order, or ordinance adopted under the plan is an offense. B, the plan may prescribe a punishment for the offense, but may not prescribe a fine that exceeds $1,000 or confinement in jail for a term that exceeds 180 days. So that doesn't leave any doubt that, contrary to Mr. Dower's position and the governor's position in this suit, that the governor has authority to enforce his orders under Chapter 418 of the Texas Government Code. And contrary to the governor's position in this case, governor has exercised his authority in his executive order GA 28. So what's happening here is the governor is just ignoring his own order in an attempt to convince the court that he has not exercised any authority, even though the order speaks directly to that authority. So the last point I want to make is the governor relies in these pleaded to jurisdiction in the case called In Re Abbott, regarding the executive order GA 13. But that case is completely distinguishable, Your Honor, because that case had no mention of enforcement. And the Texas Supreme Court found that the governor and the attorney general in that case disclaimed that they ever intended to undertake any enforcement action. So that's completely different than what you have here, where enforcement was set forth, acknowledged, and intended. In sum, Your Honor, I think it's clear that the plaintiffs in this case have jurisdiction to bring the claim. If the court has any doubt about it, I ask for leave of court so that we could bring in the TABC. I don't think it's necessary, but we'd be proud to.
But I'm going to go ahead and grant you leave to do that.
All right, thank you. And then I think you'll see the evidence at the temporary injunction hearing from my clients will be that the TABC has come on premises and told them that if they opened, they would be immediately shut down and their license would be suspended. So the TABC has, pursuant to this governor's order, GA 28, actually affirmatively enforced the order.
Okay, I'm going to go ahead and rule now. I'm going to deny the plea to the jurisdiction. Mr. Dower, give me the name of the person to be deposed, and if not, I'll come up with one.
Well, Your Honor, can I ask the purpose of the deposition? Like, what are they testifying about?
Mr. Friedman?
I think we're looking for someone who can explain the rational basis for the executive order.
Isn't that just a legal conclusion? Why it's right? I mean, I can explain the rational basis right now, Your Honor. It's that alcohol has an inebriating effect, that people that are drinking lots of alcohol are less able to practice social distancing, that bars tend to have people order at the bar.
Mr. Dower, are you going to be the witness in this case?
Well, I think, Your Honor, my point is that it's a purely legal question, because it's the intent and the focus of what the decision maker made has no bearing on the inquiry.
No, that's not so. That there has to be a legal rational basis is the legal question, but how they came up with the arbitrary and random 51% alcohol without any distinction between premises, somebody has to explain that to be a rational basis. And as Mr. Dower has indicated, they can't explain the rational basis, and apparently there's nobody who can explain the rational basis. So I'd ask that you allow us to take Governor Abbott's deposition himself.
Your Honor, before you do that, we have just filed a notice of appeal, and we're going to invoke the automatic stay on all proceedings that will stop all discovery in this case during the duration of that appeal. And that's in the chapter 54 of the Texas Civil Practice and Remedies Code. I'm happy to give the court the full site, but we need some resolution on the pure legal issue during the duration of the appeal. It's chapter.
You're appealing the denial of the plea to the jurisdiction?
Yes, Your Honor.
Okay.
And you know what, if you know what, Your Honor, if the appellate courts provide some authority one way or the other, it'll give a lot of guidance to how this goes forward.
If the case is stayed, I don't know why he's still talking, but the old rule is until we have a file marked pleading, the case isn't stayed. So is there a file marked pleading or not?
It's been filed. I don't know whether it's been stamped, but I don't think that's the.
So, Mr. Dower, I'm going to go. I haven't seen a file marked copy, so I'm going to go ahead and just so you can take it all up at once. I'm going to order. And I'm sorry, I didn't get the names. Robert, what's his name? Rowling.
Robert Rowling, Rowling. And what's the name of the other one, Scott?
Tony Furtala or Furtala.
Coleman Fertitta.
Yeah, it's in our petition.
How do you spell it?
It's the guy that owns Landry's Inc.
We understand that, but how do you spell it?
We need the court report for the court reporter. Mr. Dower, do you know how to spell it?
I'll pull it up, Your Honor.
Pilman Fertitta, Fertitta.
I'm going to order both those depositions to go forward prior to the temporary injunction. I'm not ruling, obviously, on the temporary injunction. I'm not enjoining at this point, I'm not making any rulings whatsoever on the issue of the injunction or the declaratory judgment. That was supposed to be set for next week. If this is stayed, then obviously it won't go forward next week. But all I'm ruling on today, Mr. Friedman, and I don't know that I haven't signed an order yet, so you can file an appeal, I guess, but I still need to sign an order. So, Mr. Friedman, if you can get me an order denying the plea of the jurisdiction and ordering the deposition of these two individuals, with an explanation of who they are and why you want these two individuals.
Sure.
And also, if you could include in the order the instruction that the court gave to Mr. Dower to come up with a name and that he declined to do so, or however you want to put it. I'm not trying to, Mr. Dower, you're a very able lawyer, and I think you've done a really wonderful job. Your briefing has been very good. So I'm not trying to fuss with you, but I do want to say that I was kind of surprised you didn't have a name for me, or any names for me, at least like if it's this, then this guy, and if it's this, then it's this person. And so,
Your Honor, I'd like to move to sever the case upon adding the TABC. I'd like to move to sever the TABC.
Okay, well, let's take this one step at a time. So I am also going to grant you leave to add the TABC as well.
And Your Honor, just to be clear that the automatic stay would include what you're describing, adding parties, severing.
I think I need to have an order first. So I'm not going to do anything to enforce the order. I want to get an order in place so that you can appeal it if you feel like you need to.
If there's an automatic stay, it would cover whatever the statute permits it to cover.
That'll be up to the Court of Appeals to decide, not me. So I tend to agree with Mr. Dower dealing with this issue before, that he's probably right, that once I don't agree with him that he can just stay this case before I sign an order. I think I have to sign an order and then he can file the appeal, and that would stay the case. But I don't think you can appeal me before I made an official decision.
I agree with that. The other thing is the governor can set this right by adjusting his order and allowing our clients to open up and operate with the same restrictions that every other bar in Texas that is open is operating. I mean, this doesn't have to be a monumental legal fight. This can be that these 50,000 people can go back to work.
I'm not commenting on that. So.
And we can agree to go to mediation before you sign your order, Your Honor. So I'll offer that to Mr. Dower as well.
Mr. Dower?
I think, Your Honor, we all need some guidance from some appellate courts on these legal issues. And so I think at this point, that's basically all I have to say.
Okay.
With the utmost respect.
No, I understand.
The utmost respect is welcome, but it doesn't help my clients who can't feed their families.
Anything else, guys? Mr. Friedman, make sure you run this order by Mr. Dower.
I will do so.
Get the order to me as soon as you can. And please make sure that there's nothing in the order about me granting the temporary injunction or the declaratory judgment, because I've not done that.
Of course. Thank you for your time today, Your Honor. You've been very gracious.
All right. Great job, guys. Thank you so much.
Bye-bye.
Thank you, Your Honor.
Oh, interns, if you guys could wait around.
Judge, you're still on YouTube.
Oops.